Hey, I am your former President Jefferson, from long ago, but I'm going to keep this current by having some hip-hop music in the background. Anyway, when I was the pres, there was a bit of predicament like most things when I was pres. I will be talking to you about the Marbury versus Madison trial, where the outcome of the trial led to the expansion of judicial power. Marbury was a result of a lot political struggles between the Federalist and Republican parties, during the late 18th and early 19th centuries in the United States. These struggles began as a dispute between the Federalists and Anti-Federalists over the ratification of the Constitution. The Federalists, including Alexander Hamilton and John Jay, supported ratification of the Constitution as a means of creating a stronger national government that would replace a weak central government formed under the Articles of Confederation. The Federalists believed that a strong national government was necessary to stimulate economic growth and geographic expansion, and to protect U.S. citizens from internal and external aggression. The Anti-Federalists, including George Mason and Patrick Henry, opposed ratification because they feared it would create a despotic national government that would destroy state sovereignty and be unresponsive to local interests. After the Constitution was ratified by the states, many disgruntled Anti-Federalists joined the Republican Party. Like their Anti-Federalist predecessors, the Republicans worked to reduce further growth of the national government, drawing their constituency from farmers and mechanics. The Feds, meanwhile, sought an increased role for the national government, including the establishment of a federal bank, and drew their constituency from wealthy property owners and mercantilists. During the administration of John Adams, Federalists governed the executive and legislative branches of the federal government and spread through the federal judiciary as well. However, the political tides turned against the Federalists during the elections of 1800, when the Republicans won control of both houses of Congress and elected me as president. Determined not to lose all its influence over the national government, the losers of the Federalist Congress passed legislation that created a host of new federal judgeships and called for the appointment of 42 justices of the peace in the District of Columbia. To quickly fill these vacancies during his last night in office, President Adams neglected to deliver the commission's warrants issued by the government authorizing a person to perform certain acts of several appointees. One of the so-called midnight appointees who did not receive his commission was William Marbury. After I ordered Secretary of State James Madison to withhold Marbury's commission, Marbury petitioned the Supreme Court for a writ of mandamus, a court order requiring an official to perform his duties to compel Madison to deliver the commission. Now, listen. There are three ways a case can be heard in the Supreme Court. 1. Filing directly in the Supreme Court. 2. Filing in a lower federal court, such as a district court, and appealing all the way up to the Supreme Court. And 3. Filing in a state court, appealing all the way up through the state's highest courts, and then appealing to the Supreme Court on an issue of federal law. Because Marbury filed his petition for the writ of mandamus directly in the Supreme Court, the court needed to be able to exercise original jurisdiction over the case in order to have the power to hear it. Marbury had the right to commission, and Congress overstepped their boundaries of power with the Judiciary Act of 1789. The Judiciary Act of 1789 Sec. 13 required the court to issue writs of mandamus to U.S. government officials. Thankfully, Marshall denied his request of writ of mandamus because it lacked jurisdiction. Because Section 13 of the Judiciary Act, which authorized the court to issue such a writ, saw it as unconstitutional and thus invalid. And stupid Marbury never became a justice of the peace in the District of Columbia. I was still pissed off, though. Marshall had evaded the issue of judicial review and that it was of no precedent. Plus, this precedent would limit both the lawmakers' and executors' power, which would kill our founding fathers' hearts. Now thanks to that stupid section of the Judiciary Act, the Congress has no power over the Supreme Court. Now you can see why I was mad. The court was given too much power and could declare a law unconstitutional. My failure to send an attorney to represent the government's interest made it appear that I agreed to the ruling, and you would have thought that the last 41 presidents would have done something about this.